Today is the second lecture in the process class, legal process class. We're going to be going through several topics. The best way to do this is to take notes as you're going through the lecture and you're listening to it, and then review those notes or review the lecture. I will try and give you page numbers out of the readings. Keep in mind that they jump the page numbers. Because I've taken only certain sections from each of the chapters. So you might jump from page 67 to page 93. That's normal. You didn't miss anything. It's just the way the material has been laid out. Also, in your, I understand that in your packet, there may be some pages that are duplicates. So you'll see page 97 and page 98, and then you'll see page 97 and 98 again. You can just get rid of those. It's just duplicates. It's the way it was printed up. I don't know why it ended up that way, but that's what happened. Okay, so we're starting on page 37, and at the case studies in statutory interpretation. It's important to keep in mind a couple of things here as we go through. One, we really want to know what the process is, like specifically how you get from one point to the other in the legal process. And in preparing documents and that sort of thing. But we also want to know what we have to sort of, and how things are structured in that process, and how we have to think about things. So the law, right, has got to be consistent. Keep that in your head. It's got to be consistent. And if it's not consistent, well, we run into problems with actually doing what we need the law to do, which is basically give us a structure for dealing with policy issues and problems in a consistent manner. So uncertainty, you start with a statute, right? That's one place to start. You've got a statute. Remember, a statute is nothing more than something that's been written by a legislative body in order to address an issue of some kind. We'll get into all of that. So there's a problem. As I said last time, so you write a statute, makes it seem so simple, but to the political process, and then that statute isn't necessarily clear. In other words, there are always different fact patterns. There's always different facts in any given situation. So you've got this policy, this statute written to address a problem, but there are so many ways in which that problem can crop up, and they vary in some degree. And so it's not as if you can write a statute, you've solved the problem, just apply it. It's clear how you apply it. Everybody's good. It's really an ongoing process of defining the statute through cases that come up, and you'll see that. So the uncertainty of the language, because also it's impossible to have precise language that covers all issues. That's why even the Constitution of the United States has provisions for you to go in and change, right, a piece of it, to amend it, because things change, and you'll see as we get into the particulars of that. So statutory language provides vehicles for examining techniques that the courts use to clarify the scope and effect of statutes. Okay, so statutory language is where we start. Legislative body's written it. Now it has to be interpreted, right? And it's interpreted by sort of, those who have to implement it and execute it. And they may or may not execute in a way that was consistent with the intent of the statute, or maybe they have, but it doesn't necessarily apply to the situation that they have before them, or that it doesn't really necessarily address the situation very well, the policy problem. So first, an analysis of the ambiguous statutory language illustrates general rules of statutory interpretation and construction. This is on page 37. It's pretty clear what I'm reading from the actual readings, because I will look down and it'll sound like I'm reading. So that first thing is what is the ambiguous language? When you read Supreme Court decisions, what's interesting is they spend a lot of time trying to define terms, words, that sort of thing. And they'll do things that seem very pedestrian. Go to the dictionary. How does the dictionary define this word? Look at the debates that took place in the legislative body. How did they mean to interpret this word or this phrase? How did they sort of put that together? Because they need to know what the intent was behind the statute, which means they need to know what policy this statute is designed to address and in what manner. So that's the first thing you have to do. The second thing is do an analysis of the vague statutory language, illustrating what the manner in which the courts gradually give concrete meaning to abstract statutory language by applying general terms to particular disputes. It's a lot of verbiage, but all it means is that we've now defined the terms, and now we see that there's a dispute where we think this particular statute, which is a policy resolution of some sort, might work to address that. And as we use it, right, we begin to define the terms better. In other words, the process, the entire judicial process, is one where we are constantly defining, and we're sticking with statutes right now, the language in a statute as it was meant to apply to certain policy issues. So, it's like anything else. It gets refined over time. And the thing against which they sort of refine it are the cases and the facts and cases that come before the court where we try and apply this, sort of language. Keep in mind this structure. What we have in any situation are a bunch of facts, right? Every situation has facts. Now, some of those facts in that situation are relevant to the issue at hand, and some are not. The fact that someone was driving a car may or may not be an important fact. It depends upon the issue, depends upon the case that's brought before the court. So the first order of business is always looking at what happened. And this begins really, with the lawyer, with the attorney, who someone comes to and says, there's this issue. And they say, okay, so tell me the story, right? Basically, that's what it is. And you begin to tell them the story. Their job first is to ferret through those facts and say, that's an important fact. That's not an important fact, because they understand the law and they understand past cases. They have a very good sense of that. They're still going to want to do research, but their goal is to figure out what the important facts are. The facts that aren't germane, that don't really deal with the issue or aren't necessary to deal with the issue, they're put aside. So the first thing is to cull out all the important facts and say, okay, now we've got these important facts. Now we need to know how these facts fit into the structure of the statute. And the best way to do that is to look at other cases where that particular statute has been defined by the courts, right? So you're trying to prove out the rule. Okay, I think this is the rule when looking at this statute. And you're looking at other cases to see if in fact that is the case, right? And then once you figure out what the facts are in the other cases that have led, that are similar to yours in terms of fact patterns, you can then look at how the courts decided that or how they interpreted the various terms. And then what you'll be able to do is take that and then apply it to your case. Rule proof, rule application. It's a way of saying, see, our facts are like the facts in this case, and the court decided, based on this statute with these similar facts, they're not going to be exact, but similar. That's part of the argument, is that they are similar. That basically we're going to take these and we're going to apply them now, or apply the rule to these facts, which were like the other facts that were used to apply the rule in other cases. In other words, what you're coming to court with, or what's in the process, are all these other cases. Why? The law must be consistent. Again, it's really important. If it's not consistent, then you have no law. It has to be consistently applied, consistently interpreted. And when it can't be consistent, those changes have to be incorporated in such a way that it's clear that they make sense. And you'll see the rationale for that later on, that they need to be sort of applied in somewhat a different way. Remember, what we're trying to do is take these abstract terms. I know people think there's a statute and it's clear and it's, it's written in stone, but it's not. And over a period of using that statute, in various cases with various fact patterns, we begin to understand what that policy solution in the form of a statute really is sort of structured around. So that's how we do it over time. Case after case after case after case after case. there's some other advantage to that, another advantage, which is basically as you do it case after case after case after case, not only does it become very clear to legal practitioners that that's what's going on, that this is what it means, and the courts as well, but for the general public, they understand that this is the rule now. And sometimes you'll see that where there's confusion around the rule, the courts have to clean it up. Sometimes, like in the case of the Supreme Court, they'll take a case and their interest is not doing anything else other than clarifying the point. No. This is not what we meant when we decided that case. And the appellate court, the lower appellate court, has now interpreted that incorrectly, so change it. So the court also oversees, and is obviously concerned about there being a clear understanding of their decisions, and they want to make sure that those decisions and and the ideas they've come to, or the way they've interpreted, rather, that they should be applied that way. A lot of effort, stare decisis. A lot of effort goes into making sure that that's consistent. So don't ever lose sight of the fact that the language is going to be imprecise, and the ambiguity allows for us to work and rework the meaning of it. You'll notice whether it's the Constitutional Convention or whether it's the Supreme Court looking at a case, there's a lot of interpretation of words and terms and what they mean and how they're used and what their purpose is and so on and so forth. So you get all kinds of facts that you have to work with, and obviously, you have to look at evidence, and there's different types of evidence. Why? Evidence really are tied to the facts, right? If you come across a bloody, rag somewhere, is that applicable evidence or not? Well, it depends. What kind of case do you have? Whose blood is on that particular, cloth or whatever? And so you have to think in terms of what we call extrinsic evidence, right, and intrinsic evidence. So when we look at a word, we have to tie that evidence to some sort of understanding of the language, right? So in page 39, they say, thus intrinsic evidence of the intended meaning of the word sex in section 703A, and they're referring back to an act of Congress, is helpful but inconclusive. The way they go ahead and they the intended meaning of the word sex in that particular statute is helpful, but it's inconclusive. It doesn't tell us enough for us to deal with the case beforehand and resolve anything. So a court interpreting sex would likely seek guidance from extrinsic evidence, such as legislative history and so on. In other words, we know the intrinsic meaning in the word or the phrase. We know it's there, and we have, but it's unclear exactly what was meant. Even something as simple as sex. What does that mean? And then you have to look at things outside of that statute, and you have to think in terms of, okay, we got to figure out what this means. Look, ambiguity is the norm in life, right? Nothing is really ever clear, except my exams. Nothing is ever really clear in terms of being absolute. For example, even defining the word sex, there's a book written a decade or so ago called Lust in Translation. Lust in Translation. And there, the author looks at different cultures and how they define sex and what appropriate sex behavior is. So if you look at, I'm not obviously talking about gender here, I'm just saying sex, okay, the act. And so if we're looking at that, and you look at how many different ways that's interpreted, in different cultures, like what constitutes, for example, an infidelity. When you think of the various sexual acts, where does that begin? Where is the line being crossed? So for Americans, back then anyway, having some sort of correspondence with someone via computer, the internet, since no matter what is said, no matter what is done, there's actual no physical contact. Americans say that's not really sex. I don't know if their partner would agree with that, but the point is, even something that we think we know the definition of, turns out that it really moves and turns based upon a whole host of factors, including the way it's been looked at and used in the past, right? So, all right. So it seems often obvious, but we have to go outside just what was meant in the legislature in order to really put a meaning to an understanding, all right, to a particular term even. Now, I know this seems very mundane and very laborious, but it is an essential part of the process, and actually it's an interesting part of the process, because defining terms and words and the intent of them and how those interpretations fit into the statute which resolves a policy problem, hopefully, or is a policy that solves a problem. The vagueness is where all the action is. So even if the legislature chooses its words carefully, most statutory language is necessarily general, because almost all legislation addresses broad categories of activities or disputes rather than particular cases. In other words, it has broad application. There's something else here. In order to get people to pass a piece of legislation, sometimes you have to kind of, change the verbiage, put things in, take things out to get support. And that support is maybe driven by constituents. I can't support that legislation as it's written because my constituents won't vote for me again, or I will lose major donors to my campaign, and I need that money in order to run for re-election in order to keep my job. So we've set up a ridiculous process there in terms of a campaign and campaign finance and the like. Nevertheless, all right, so there are these broad categories. The old saying is, you never want to see sausage or legislation made. It's just messy and it's a little unsightly, right? So courts put the flesh on the bones of legislation by applying the general terms, this is page 40, of the statute to the facts of particular disputes, thus adding precision to statutory language in much the same way that they develop common law. We'll get to common law, incrementally and in the context of successive disputes. Okay, let's put this in a real simple scenario. So you're a parent, and the rule is that there is absolutely no snacks before dinner. Let's just make that a rule. Okay, so that's the rule. Everyone knows it. We've defined snacks. We know what snacks are, right, which is an important thing. I mean, an apple is not the same as a candy bar, but, for the purpose of our legislation in the home, right, we're going to say that that's a snack. So defining what a snack is the first snafu. There's something that's good for you, and then how you define something good for you. Is that considered a snack? Okay, so now you get fact patterns, right? So, a child comes home and has had a miserable day at school, been made fun of, wasn't selected to play with a certain group, and they come home distraught. And they say, can I have a donut? Now, a donut, I think most of us would define as a snack. Even health food type or healthy donuts are snacks. Now, the rule is no snacks. Easy to apply. So you say to the child who's now distraught over coming home and being made fun of and not being selected to be on a team in a sport, no, there's no snacks before dinner. Or do you make the exception? And you say, it was a rough day today for you. Come on, let's have a donut, right? Now, some people say that's horrible. It's the wrong thing to do. You're not only breaking your own rule, but you're teaching the child that eating is a way of sort of dealing with life's stresses. It's getting complicated now. Let's complicate it further. A sibling comes home after this and has had a great day in school, and they say, "How come he or she is getting a donut? Had a hard day in school." Well, I had a hard day in school. What kind of a day did you have? Well, we had a test. Well, that's not hard. You expected the test, you studied for it, and it was under your control. So now, something being under your control is now part of whether or not you get the donut. Do you see what's happening? And then the next week, something else happens, and the rule gets reapplied. One of the great difficulties in parenting, right, is that you've got people have to agree, the adults have to agree on the verbiage. It's much like legislation. No. A snack is a snack. I don't care that there's a rough day in school. They've got to learn to deal with that. You talk about it. You don't shove a donut in their face. It's just one donut. Doesn't matter. The rule is no snacks. You see how it gets. So even a snack after school, before dinner, which is disallowed, becomes a major, legislative constructive issue. And on it goes. On and on it goes. It's nothing in life can be written up so precisely, so clearly that there's no exceptions to it, that there's no, need for reinterpretation. So we keep reinterpreting it. And so maybe after several instances of donuts after school when there's been a hard day, we realize that no, the child is actually now has 27 cavities. And so we say, well, wait a minute. We need to change the rule, right? Now it's only things that won't give you cavities. See, that's precedent. You've now changed something because you realize this doesn't work. And you didn't realize it didn't work because you didn't think of the fact that there could be cavities. That wasn't included in the debate. It wasn't included in the facts. No one mentioned that. And so that's why we have to do it. It's successive context. We learn and we sharpen it so people understand. We have to have a consistent logic behind it. We just can't willy-nilly go around changing things because, after all, we can. Every time we change something, every time we interpret something in the courts, through that legal process, every time lawyers win the day and can get the court to sort of see their point and something changes, what we have is we have a new twist to the rule. I mean, think about Plessy versus Ferguson. Separate but equal is okay. Fast forward several decades, and you get Brown versus the Board of Education, and that rule doesn't apply anymore. Separate but equal, different races have different water fountains or whatever, so they both have a water fountain, so what's the problem? Separate but equal is okay. Then we get to Brown v. Board of Education, and it turns out separate means it can't be equal. Now you would think that's pretty obvious, but several decades before it wasn't. The standard was different. The culture has changed. We've become more aware of certain things. We give greater weight to certain things now than we did then. That's how a culture grows. That's how our awareness of things grow. That's how we get better as human beings, right? We learn to adjust so that we can, over time, we learn. That's the way we human beings learn. You experience things, you take from it what you can, and you begin to change, your behavior. You act differently. So basically, you're always going to have a certain element of confusion around any statute. And therein not only lies the problem, but the opportunity for the process. The process is important. You can't allow that to break down because that's how we all know what's going on. And that's how we know what behavior is acceptable and what's not. So this all comes down to, obviously, judicial interpretation of legislation. Remember, the judicial branch had nothing to do with actually sitting down and writing the statute or figuring out the policy prescription. What are we going to do about this particular, issue that's cropped up? Okay, and does it make sense or does it not make sense? One of the cases that very contentious and has driven a lot of politics over the last several decades is Roe v. Wade, the abortion case, and we think in terms of how important words are, that it's now been couched in terms of pro-life or pro-choice. Now, who would be against either one of those things, choice or life? But even by changing those words from abortion and anti-abortion, you put a more a focus on the particular issue that you think is most important, which is choice, right? Or whether or not there's a right to life or choice. That's how it gets couched. Now, nobody would argue that either of those sound bad. But how do they get used? What's going on with them? How does this affect freedom? I mean, it's a complicated issue, and the court in that case tried to resolve it with the wisdom of Solomon. And I think most people, while we look at that decision and understand the intent of it, but I don't think anyone looks at that and says that's a great, clear, precise decision. And this is what happens when the court gets involved in trying to be active and doesn't really resolve, because not all issues can be resolved. I mean, whether you are pro-life or pro-choice comes down to a whole bunch of things in the way you perceive your world, right? So there's some language in some statutes and in some cases that take a long time for us to understand, and we may never really come to total agreement on, and on we go. And one of the reasons why legislators have not really addressed that issue is it's so contentious that you could very easily be on the politically, in terms of being reelected, wrong side of that issue. You may actually have a feeling in one direction, but have to advocate for the other. I know that sounds, somehow disingenuous, and it is in some ways, but politicians are politicians. Hypocrisy is no issue. It's it doesn't matter. Somehow that's okay for them. All right. So judicial interpretation, is important. So attorneys make those arguments before the courts, and the court has to make a decision. So this is on page 42, can opposing attorneys reasonably argue for and against application of the statute? Can different judges reasonably reach opposite conclusions on the proper interpretation and application of the statute in any given case? Right? Yes. It's odd, right? We tend to think of the courts as sort of, especially the Supreme Court, as the final arbiter of what the law means. That doesn't mean they don't revisit it later on and it doesn't change. But here's the key element. It changes logically. That doesn't mean it's correct logic or culturally, correct. It changes in a way that the court has to explain itself. So the law is somewhat clearer. It's being refined. And so word goes out to the public and the politicians that this is how the court looks at this. And we want to be consistent with that. So, you'll look at legislative history, you'll look at a whole host of things, but the key thing here is that the one constant is change, and there is ambiguity and uncertainty in the law, but we don't want ambiguity and uncertainty. We want to minimize that so that we can deal with change. Huntington wrote a book called Political Order in Changing Societies. Everything changes. But how do you keep your institutions, which serve an important purpose, functioning as that change happens? And then there's a lot of interesting components of that. But nevertheless, that's the point. I don't care if you're a college student and you're taking a professor for a class, and that professor is not able to finish teaching that class for whatever reason. Now a new professor is brought in. There's a major change. Will this new professor just follow the old syllabus? Is he or she required to do that? Those students who the new syllabus, if the professor enforces that, would do better in the class, want it. Those that feel like, look, I've really prepared for the old syllabus, don't want it. And there's a conflict over this. So how do you resolve that? You couldn't get the professor back in the class for whatever reason. Let's say it became ill. And now everything's changed. And even if the professor, she says, I'm going to stick with the old syllabus, it's not going to necessarily be taught in the same way. Or maybe the books and the chapters assigned will be weighted differently. There's change. Now, is there an option for the students to stand up and say, I'm going to leave? Well, it depends upon the moment in time. If it's the second day of class, not a problem. If it's in the middle of the semester, more of a problem. If it's at the end, major problem, right? And you're bound to have people that are unhappy with it and say, I don't like that there was this change. So it's inevitable. It's inevitable. It happens all the time. It happens with me putting lectures up and thinking, okay, the students need more time to read this, or I just lost a lecture trying to put it up, and now I've got to redo that lecture. And that takes, several hours to do. So nothing ever runs smoothly. The one absolute is there are no absolutes. As a serious student of the law, right, this is on page 44 now, or possibly a future legislator, or simply an engaged citizen, you should not be content to comprehend and interpret statutory law. You should also carefully evaluate the merits of current or proposed legislation. Most citizens don't sit around and think, oh, so what do these guys in Congress have on their plate today? Let's take a look at that. Let's see what they're doing. Let's listen in on those hearings. Most people are busy trying to feed themselves and their families, deal with medical issues and losing their jobs, and a whole host of issues. Most of us are busy trying to navigate through our own lives. and we entrust our representatives to understand that, and then write a policy that is consistent with addressing the issues that we're facing. Law is really about policy. When you get to the next level of understanding this material, you realize, and there's a great book on this called, Getting to Maybe, which is about, policy prescription. That's the artistry of legislation, the policy, and having policy that's as exact as you can get it. So when you encounter a social problem that you believe is not adequately addressed by current constitutional or common law, consider whether you would support legislation to address the problem or not. Does this do the job it's intended to do? If you're in the legislature, you're in the courts, or you're an attorney, you're looking, saying, does this work or not? Remember, the law is adversarial for a reason. There are two sides, in most cases, right? Two sides. And the idea is that each has to make an argument. And hopefully, as they make their arguments, right, before a jury or a court, depending upon what it is, appellate court, what have you, hopefully from that springs an answer. So we like the adversarial nature. It's critical because there's an invested interest on both parties' parts to find an alternative way to view this, whether you interpret it that way or what have you. And so it really helps sort of, clarify things as they sort of fight it out. In Brown v. Board of Education before the Supreme Court, go listen to it because you can. They record Thurgood Marshall in that case when he was heading the NAACP. Listen to his argument. It's not an argument that runs down the law, because he understood we've got to change this. And if we try and get it through the legislative body, it's going to take forever and it's going to be political. But if we go through the courts, we might be able to get the courts to interpret it in such a way that we can get what we want, right? But you have to mount the argument. So you would think that you'd go in and have all these, incredible arguments, but he understood, and this is the genius of it, that you had to make the court understand that who we are as a people and what we claim is important to us, right, really manifests itself in how we treat one another. So when you hear him say, and I'm paraphrasing, terribly paraphrasing, that look to the court, during his 30 minutes of oral presentation, he said, look, don't worry about these black children, we called them Negro children at the time, I believe. They'll be fine, they're used to this, and you think, oh my, that's horrible. No, they're used to this. Think about what it does to us to allow it, though. This defines us. Is this who we want to be? It's a stroke of genius. It's like, I'm not going to go and make an argument about the particulars here. They are there. But let's just move right to what it does to us as a society to do this, regardless of its impact. And he waves that aside in some measure. Usually the court, during oral arguments, is ready to challenge. They've read all the documents and they're ready to challenge what's being said. You go back and listen to that. There's an awful lot of silence by the justices. He's making an impassioned, logical argument about who we are as a people. Don't think it's just about this case. No, this helps define who we are. You ask yourself, is this who we are? Is this who we want to be? Is this how we want to behave? If you listen to that oral argument before the court and others, you begin to see that there's an artistry to this, that you get beyond, the policy to the culture and to the people. But you better be well-versed in the law, and you better understand the intricacies of that process to be able to pull that off. It's not easy to pull off, right? You can't willy-nilly do it. You have to build, an argument that leads everybody to that door. And you say, you really want to keep this door open, or do you want to shut it? And do you want to end this? I'm not sure many people could have done that, but he managed it. And it is, I think it really helps elucidate the point that we're trying to make here. The idea here is that, remember, legislators can enact legislation, but they also have the power to repeal it or amend it. Gee, we did this, we thought it would accomplish that, but it's not really doing that. Or there's a better way to do it. And you'll see as we lay those out in a bit. All right. the amendments are important. It's a way for the legislative body, just like changing court decisions by the court system is a way of changing past processes. All right. So on page 47, we talk about the relationship between legislation and common law, and the interplay between legislation and common law. Legislative primacy. Although, this is 47 again, although the legislature and the judiciary both exercise lawmaking powers, the legislature is the paramount law-making authority, and legislative enactments supersede inconsistent common law. When Congress writes legislation, it is the law of the land. The courts interpret it. So first, they're supposed to write it, and then the court, when there's a case, the court's passive in this, when there's a case challenging it, as the lawyers go at it, they move into the court system, and the court has to define it. Sometimes nothing's been said in that area of law, or very little, or nothing applicable, and then the court itself has to figure out and extrapolate from things that are similar, or just from their understanding of the structure of everything, exactly how this should be interpreted, right? So the Supreme Court tries to apply things as well to state governments and the like to keep things consistent. All right, so legislation, then, think of it in terms as guidance for common law. 48. Even if no statute currently applies to a dispute, a court may decline to extend common law principles to the area if it concludes that the matter is better left to the legislative action. We're not going to resolve this. Congress needs to resolve this through policy prescription. Right? Moreover, if the court decides to develop and apply the common law, it nonetheless may look to statutory law for an expression of public policy that helped the court formulate the common law rule. Legislators have figured out there's a problem, and they've come up with a policy prescription for it. Now there's a conflict. The courts say, well, what do these guys want to do in the legislature? What was the intent of this, and how can we remain consistent with it? Now, sometimes common law, right, is as background for legislation. Although statutory law supersedes common law, the common law at the time of a statute's enactment may provide a helpful context for analyzing legislative intent. It's an integrative process. If a statute overrules a common law rule or seeks to address a problem left untouched by the common law, a court can better understand the statute's intended scope if it appreciates the deficiencies of the common law to which the legislators respond. We thought this. They're responding that way. Obviously, we're missing something here, right? All right. Conversely, if a statute codifies existing common law, cases that develop the common law rule obviously will provide guidance in interpreting the statute. Okay. Moreover, statute often addresses only selected issues within a general subject matter touched by the statute, thereby creating gaps that common law may fill. In some cases, the statute itself provides for reference to common law, as in the Uniform Commercial Code. The UCC governs interactions in the commercial sphere. The court also, by the way, gives greater weight to regulatory bodies writing regulations because they're experts in that particular area, and the court weighs their decisions heavily when they make a decision because they're regulating an industry that they know a lot about. In other cases, statutes only implicitly incorporate common law principles. So it's an integrative sort of process, right? So the next thing we have to think about, and you find this on page 49, judicial power and limitations regarding legislation. Although legislatures can modify or override common law principles developed by courts, the courts retain an important role in the development of statutory law. Courts may review statutes for consistency with constitutional requirements and will refuse to enforce unconstitutional legislation. Right? The courts determine the scope and the effect of legislation by interpreting statutes and applying them to particular disputes. Nonetheless, the courts have less flexibility in interpreting statutory law than in developing common law. Okay? Again, they have less flexibility in interpreting the statute because there's legislative intent than they do in developing common law. Okay? So a state or federal legislature is the primary policy-making body within a jurisdiction, and it can modify or overrule common law by enacting a superseding statute. The courts have decided this. We're going to now clean that up a bit with another statute that explains that, no, you can't do it that way, or you can't perceive it that way. the court then can look at that from Supreme Court from a constitutional point of view, and make a decision. So it's an interactive process because it's not an exact process making policy, prescriptions through legislation. Words and meaning rule the day. Ambiguity and inconsistency don't help, and you try and minimize as best you can. Things keep changing, which just make it harder for us to write law and interpret law in a way that's going to be exact and consistent. But look, that's the whole point of a representative government, is to be able to argue these things out so we can get to a point where we understand exactly what these things mean, right? So we understand how we're supposed to interpret the rule so we can all follow it. Every single case that's adversarial, the vast majority of them, there's an issue. And there's a challenge to this process, making the outcome consistent so we understand what the law is. That's no easy task. So what does this really mean? It means that we're going to change things. Eventually we change things, right? The role of precedent, this is Chapter 5, and it starts on page 53. The role of precedent, the court system, and stare decisis. That gets pronounced differently depending on what part of the country you're in. Introduction to it, right? Previous court decisions may influence or even dictate the results in a dispute currently before a court. The legal effect of the previous decision is governed by a complex set of conventions for which the Latin phrase stare decisis is often used as a convenient shorthand. It means standing by what has been decided, trying to remain consistent with what's gone before. The doctrine itself, the court endeavors to decide each case consistently with its own previous decisions, which are called precedent. Moreover, the deciding court ordinarily is strictly bound by the precedent of a higher court that reviews the decisions of the deciding court, if the precedent addressed essentially the same question currently before the deciding court. Look, when the Supreme Court makes a determination that the lower court had it wrong, they'll just send it back down and say, correct yourself. Change this is wrong. And then the lower court does that. Sometimes the Supreme Court will reinterpret, right? So the doctrine of stare decisis serves several significant goals. The first, now on page 54, it promotes efficiency in judicial administration by relieving judges of the burden of revisiting settled legal questions in each case. There is such a thing as black letter law, which means this is so well accepted, this particular thing in the law, statute, what have you, that we don't really revisit it anymore. It's like this is accepted. We all accept it. It's at the core of what we do, and we don't argue this out. But most of it is not, right? Second, it facilitates private and commercial transactions by ensuring a degree of certainty and predictability in the law that regulates such transactions. Again, it's all transactional, right? It tries to create predictability and consistency. That's what we all want. But we don't want something, again, that's inflexible. It seems like I'm making the same point over and over again. If that's the way it seems, in fact, I am doing that because it is the foundation of our structure. Okay? So the strength of an authority as precedent depends in part on the relationship between the court that created the precedent and the court that may subsequently apply it. And there the danger is fact patterns, right? Different moments in time, cultural changes, a whole host of issues. So they look at what it was, and they say, is it still should it remain that way, or do we need to make some adjustment? All right. I'm going to leave up to you to look at page 55 and get a sense. They use the California court system, so you get a sense of what it looks like. On page 56, there is the structure of, again, that California court system, and also then we look at the federal court system, which is similar to that. So you look at California first, and it looks similar. So at the bottom, you have the United States district courts within the Ninth Circuit. There are these circuits. They're called circuits because originally the justices would ride around, certain states, and then they'd sit and they'd hear cases. Obviously, that was burdensome, and it was best to put the court in one place. At first, they didn't have a home for it, so it went into the basement. Tells you how they sort of, gave weight to the court. And then above that, there's the United States Court of Appeals. And again, it goes, so district courts, and then you've got these first line of appeals. There's the First Circuit, Second Circuit, Third Circuit, and so on and so forth. There's the D.C. Circuit. There's the Federal Circuit. So there are a bunch of those, and then from there, it goes up to the United States Supreme Court. If the United States Supreme Court, the district courts that are set up within a particular circuit, right? Think of a circuit as a state. I almost hesitate to do it this way because I don't want anyone to be confused, but think of a circuit court as a state. Circuit courts like the Ninth cover many states, but just to say it's a state. And the district courts could be all the counties in that state. So you go from the counties to the state, and then in the state, these are appellate circuits. Then it would go to, say, the federal government or what have you, the United States Supreme Court, if they want to hear the case. So the primary federal trial courts, right, are the United States district courts, with a few exceptions. There's always exceptions. And then the appellate courts are the 13 circuits, and so on. Look at that little map, and you'll get on page 56, you'll get a better sense of that. All right, so court structure. Precedent has only limited, stare decisis effect on the decision-making of the court that created the precedent. Although a court will do so only in unusual circumstances, it can depart from its own prior rulings. We've already talked about that, right? You should look at the scope and application, on page 57. You should follow that all the way through, it's to where it says two limits, right on. Stare decisis help to avoid rigidity in the law while maintaining consistency, distinguish a prior decision, court revisits its own precedent by indistinguishable form of dispute, something is different, and so on. Then there's analogy, right, a distinguishing precedent, also on that page, which you should also familiarize yourself with. Homework for you is not only listening to the lectures and taking your notes, it's also reviewing what I'm touching on, especially when I say, look this over. I'm not going to review it. Now, just so you understand, there's two reasons why I do that. One is because I don't want to beat a dead horse. It's really tied to things we've already talked about. And the information there is the second thing, should be readily accessible to you because you have something to build on it, so you can kind of understand it. So you should do that. And that brings us all the way through, to the example on page 61. Examples, this example especially I like because most people can relate to it. But when you look at the examples, and there's a whole bunch of them in the readings, it's always good if something's unclear to look at an example. Examples, if well done, should help clarify the problem, right? So here, on page 61, we're dealing with warrantless searches of cars, houses, and mobile homes. It's interesting. You've got cars, we all know what a car is, and you've got houses, we all know what a house is, and we got mobile homes, which are sort of a mix of the two. So how complicated this gets. So I'm going to read this thing, and I'm going to try and really make clear what we've been talking about, the ambiguity of language. And then on page 62, there's a little graph which makes it very straightforward. Supreme Court decisions interpreting and applying the Fourth Amendment to the United States Constitution illustrate the technique of analogy and distinction, as well as the difficulty of predicting legal outcomes. In Carroll versus the United States, the Supreme Court held that the Fourth Amendment permitted federal officers to search an automobile without first obtaining a warrant. Stop a car, you can search the automobile. Now why? The court reasoned, although a suspect may have privacy interests in the contents of an automobile, the ready mobility of the automobile makes it impractical for officers to obtain a warrant before searching. It's not practical. We pulled you over, sit there, we're going to get a warrant, and we're going to come back and search your car. This may take us a few days, or it may take us a few hours. 7 months later, in Agnello versus the United States, the Supreme Court held that the Fourth Amendment prohibited the warrantless search of the home of a suspect who had been arrested in another location. In disapproving the warrantless search, Agnello Court distinguished Carroll on the basis of immobility. That was the key. Cars are mobile, houses are not. And so you can take your time, or you have some time to go get a warrant of the house and the particularly great privacy interest that the owner has in his contents of a house. We have more privacy rights in our homes than we do in our cars on the road. We're in public. 60 years later, Carroll and Agnello in California versus Carney, the court considered whether the Fourth Amendment prohibited law enforcement officers from engaging in warrantless search of a fully mobile motorhome. It's both. It's a home and it's mobile. Neither Carroll nor Agnello clearly controlled, because a motorhome arguably combines the mobility of an automobile and the privacy interests associated with a house. Now think about this. Before there were mobile homes, right, this was not an issue. Along comes a mobile home. Now it becomes much more complicated. Now it's about, okay, what do we, how do we treat this? It's mobile, but it's also a home, right? Consequently, the result in Carney, under the doctrine of stare decisis, depended on whether the court found the facts of the case to be more nearly analogous to those of Carroll or those of Agnello, and the next step in the court's continuing interpretation of the Fourth Amendment. On a vote of 8-1, the California Supreme Court had disapproved the search on two grounds. First, it had analogized Carney to cases like Agnello, reasoning that the nature of the contents of the motorhome in which the defendants were residing created similarly high expectations of privacy in those contents as the privacy expectations that one has in the contents of a house, page 62. So what are they saying? We think a mobile home is more like a home. It has a higher level of privacy, even though it's mobile, right? Second, it had distinguishing Carroll on the basis of the comparatively low expectations of privacy that an owner has in contents of an automobile. Most of us, I think that we have a greater right to privacy in our homes than we do in our cars, right? Okay, so if you look at the bottom of page 62, you see that broken out and how the court sort of viewed that. Now, what about overruling precedent when you're going to go ahead and depart from the normal application, right, of how we want to be consistent? A court's own precedent, or that of a higher court within the same jurisdiction, normally is controlling if it is materially indistinguishable from the dispute now before the court. Let me clarify this. You're going to build an argument for your case. You're going to look, based on your fact pattern in the area of law, for cases that are similar to make your argument. So first place you're looking in your own state, your own district, looking for similar cases. Why? Because those cases were applied where you are. If you go to another, say, appellate court in the circuit or in a circuit, it becomes, well, even though the facts are the same, that court may view it differently. So there is a lot of play in a sense. And so the best support for your argument is always in the same physical, geographical area where cases like yours have been decided, because it's closer to what the court has defined in that area. If you don't have any of those cases, you have to go outside that area, but the argument gets weaker because there's other interpretations. So you still have to overcome that barrier that there could have been a different interpretation in the other court. All right, you should read the rest of that on page 63. It's important. Again, for exams, what you're going to see is in these sort of matching multiple choice questions, which I will explain before we do the exam, is terminology and concepts. And you have to make a determination about what that concept means, and what the determination, of how it may be used. All right. So you should. The next thing that's important is on. I want to talk about is on page 65. Dealing with unworkable precedent. Okay, developing a technique of legal analysis, there are 4 considerations that are particularly important. 1, the hierarchical nature of authority, policy analysis, synthesis of incremental authority, and developing arguments for both sides. Okay, this is, there's a great deal of information here that is important. And what I'm going to do is I'm going to end this lecture here, pick it up in the next lecture. So that will be sort of lecture 2A. I hate to say that. I'd like it to be lecture 3. But we're going to stop this here because this next piece, I really want to make sure that you're able to focus on, and I want to spend some time on it. So we're going to end this lecture here, and